Okay, we are live streaming on YouTube. It will be on the county website momentarily. You may begin.
Thank you, Olivia, and good afternoon to everyone. I want to welcome all to this meeting. I'm Warden Hicks, and this is a meeting of the Development Charges Hearing Committee. I'm the chairperson, and today we are meeting as a tribunal. We'll be hearing a complaint pursuant to Section 20 of the Development Charges Act, 1997. I think more specifically, Section 20, sub 1, sub C of the Act. I want to introduce the other panel members. Councillor Akash Desai is one of the members. He's just waved to you. And Councillor Woodbury. John Woodbury is the other panel member. Mr. Moser is the complainant. And if you would wait, yes, that's him. And representing the county is lawyer Errol Treslin. The committee is being assisted by staff from the county's legal services department and the clerk's office. And I would, since this hearing committee must hear an appeal of the county's own bylaw, council has directed those staff to assist the committee and to operate at arm's length from other county staff in respect of this appeal. As a preliminary matter, I invited county staff to advise if they wish to be involved in this appeal as a party. And it is highly unusual for a municipality to have to adjudicate on its own bylaws in this manner. And I felt it would be helpful for the committee to have the benefit of submissions from the county in respect of the bylaw. County staff advised that they wish to be involved, and as such, I have ordered that they be made a party to the complaint for the purpose of making submissions on the bylaw. There were some pre-hearing discussions that took place with the parties on several matters, and that's been helpful. And they have agreed in order to focus today's hearing on the following issues, and I'll go through some of them. Number one, that this hearing can proceed electronically. And as a pre-hearing matter, the parties have consented to an electronic hearing over Zoom and waived their right to an in-person hearing. And this has been very helpful in convening this hearing in light of ongoing pandemic-related restrictions. Secondly, documents were exchanged. The parties have provided copies of the documents they have indicated they will be referencing during this hearing, and they have been provided to members of the committee. The applicable bylaws. I note that the hearing committee considers this hearing to be in respect of both county bylaws, so 4949-16 and 4950-16, each as amended, which together represent all of the county's development charge bylaws currently in force. Certified copies of the bylaws have been provided to the committee members and as well to the parties. There have been a number of facts that have been agreed to. I'd like to run through those. The parties have identified a few basic facts that they are agreed on with respect to the complaint, and they are as follows. Number one, Mr. Moser intends to build a 3-season cabin on White Cloud Island. Number two, the cabin is for residential use. Number three, Mr. Moser has been required by the Township of Georgian Bluffs to pay county development charges in respect of pursuing this building project. Number four, White Cloud Island forms part of the Township of Georgian Bluffs and part of the County of Grey. I would ask both sides if you would confirm that those are the agreed facts. Mr. Moser?
Agreed.
I didn't hear you, Mr. Treslin. You're muted, sir.
We agree, sorry.
No worries. And I wish to confirm that both sides are prepared to proceed to the hearing. If you would just confirm.
Yes. Yes.
Okay, so with that said, the hearing will proceed as follows. First, there will be evidence from each party. Mr. Moser, you'll be going first, and then the county. There will be submissions, secondly, submissions on the bylaw, if any, from each party in that same order. So first, Mr. Moser, and then from the county. And thirdly, the committee will then consider its decision. So more specifically, the complainant's evidence, that's you, Mr. Moser, you will present your evidence. And once you've presented, Mr. Treslin may ask you questions, sort of cross-examination. And you will have the opportunity for rebuttal evidence if you so choose. It can be presented, and then, of course, it can be examined as well. The county will then proceed in the same manner. So they will present their evidence, and then Mr. Moser, you will have an opportunity to cross-examine on that evidence, and they will be able to put in rebuttal evidence if they so choose as well. We will then move to submissions. Mr. Moser, as I mentioned previously, you will be making submissions on the bylaws first, and then the county will be invited to do the same. At the conclusion of all of that, the committee will meet to consider its decision. Are there any questions?
Nope.
Excellent. So with that said, we can proceed. Mr. Moser, you now have the floor.
All right, thank you. I will try to present my PowerPoint. Right. Can you see this?
Yes, I can see it, but just by way of procedure, I just want to take a second to consult our lawyer about introducing into evidence this PowerPoint presentation. Well, do you suggest we do that at the beginning or at the end of the presentation? Okay, so the suggestion is that we introduce your PowerPoint presentation in evidence, and it would be treated as Exhibit 1.
Thank you. So
sorry, Mr. Treslin, any comment there?
We received that about an hour ago, and we have no objection to it being introduced.
Okay, so that'll be treated as exhibit. Are we using A or 1? I think it's Exhibit 1. Very good. My apologies, Mr. Moser. Go right ahead.
Thank you. Okay, dear Warden Hicks and dear council members, as you are aware of, I would like to the council to consider waiving the development charge for a project I'm pursuing on White Cloud Island. So it's a 3-season cabin, small cabin with 2 bunkies. I got approval from the Grey Sabel Conservation Authority. I got approval from the township, but it's pending the payment of the development charge. Development charge imposed for the project is $7,524, and I would like the council to consider waiving this development charge. Please feel free to ask questions if something needs clarification from your side as well as I'm going through this. I'm trying to be short and getting to the point. So the land on the island is cheaper compared to the mainland due to the lack of access and services. Cottages on the island tend to be simple, off-the-grid cabins. There is no services, no hydro, no fire, no emergency response, no roads, no waste management, limited access to boat launch and docking. Season lasts from May till October, no access in the winter. Weather conditions, especially specifically wind, limits the access to approximately 2 weekends per month. Doing some math on it, this kind of corresponds to about 6.6% of usage compared to a residential unit on mainland. I want to show quickly what I mean with wind. East wind compromises the channel to get across to the island. This is open to the Georgian Bay, and the waters of Georgian Bay are no joke. There can be some really big rollers coming through here, and east wind is a no-go to boat across here, especially not with my equipment. Northeast wind compromises the boat launch in Big Bay. The water comes straight in here. The boat launch is not protected. The boat launch can only be used with west wind conditions, basically. So what I want to point out here, there is not a lot of infrastructure in place to actually access this island. Water conditions are not great around the island. Reliable access is not a given thing. As part of the building permit application, I've been asked to sign a document called a site plan agreement with the Georgian Bluffs Township. I want to point it out, that's not between me and the county, that's between me and the township. Basically, the document covers a few things. I needed to establish an acceptable mainland parking facility for my boat, for my trailer, for my car. I need to establish an acceptable method of solid waste disposal. The owner also recognizes that should an emergency occur on the island, that local emergency services personnel may not be able to respond in a timely manner, if at all. So this document kind of reveals the general understanding that the island lacks services. It puts the onus on the owners to arrange for the access to the island. I just want to put that as a bit of a context to my complaint. If I look at the development charge fee structure that you're outlining, a single and semi-detached 7,524, a townhouse or multiple residential units 5,239, an apartment unit 4,400, wind turbine, and then non-residential. There is a fee structure in place that the bylaw recognizes the need for differentiation. The island is hardly residential and should be considered in the fee structure. Charging 7,524 for a cabin on White Cloud Island does not seem in line with the above. So I'm asking the council to consider my case and waive the imposed development charge. Out of these reasons, the island is hard to access, and the given infrastructure does not allow for proper occupancy. It should not be considered as fully residential. I personally managed to get to 6.6 occupancy compared to a mainland property. This means I'm using less than 6% of the services compared to a normal occupant on mainland. The county's infrastructure is inadequate to serve people on the island. From section D of the development charge and background study, I gathered that as required by legislation, consideration should be given to adjust the development charge rate structure and calculating the charges on area-specific basis. The county staff chose not to do this as defined by the bylaw, and the bylaw applies a flat charge across the region. The other side will argue that's basically what the bylaw says, and I will not have a right to actually get a reduction or an exemption from the charge. In my opinion, that's not a very differentiated approach. I think the island considers a bit of a special consideration out of the reason I mentioned above, and I'm asking you to reconsider this in my case and waive the development charge. And that's it. I want to keep it short, not taking too much of your time. Thanks for your attention.
You're muted, Gordon.
I just muted myself. I apologize. Thank you, Mr. Moser. Mr. Feslin, your turn.
Thank you. Mr. Moser, I just have a couple questions for you. Can you hear me okay?
Yep.
Great. Where do you primarily reside, sir? Where's your permanent residence?
Kitchener.
Kitchener. And I take it that you don't fly to this island. Do you drive up to get to the island?
Yes.
So I just want to be clear that in order for you to get to your island we call the cabin. Is that what you're gonna call it?
Yeah,
Would you agree with me? You're gonna have to use county roads. You're gonna have to use Grey County roads to get to your cabin. Do you agree with that?
I agree with you.
And if anybody has, I saw from your, you have some kind of agreement with the lower tier municipality about services, and they asked you to agree about the emergency services, but you're aware that the emergency services are actually provided by the county, are you?
I agree. I'm aware of that.
So if you have a heart attack out there, or if there's an accident, you're going to be looking for emergency services. I'm not sure how quickly they're going to get there, but maybe I'm asking you to agree with the obvious. If there's an emergency that requires life-saving medical attention, you're going to be calling 911. Agreed?
Yeah, I hope it's not going to happen.
Oh no, I agree.
I have to say there, I will probably first call my neighbor across the water to pick me up before I will call 911. Or if I need an airlift, I would directly ask for an airlift, because I don't think that you will be able to respond in time on the island.
No, I understand. And basically, by deciding to build out on the island, you've paid a lesser price for the property, and you've accepted as part of that plan that you're not going to have the services out there that you'd have if you were off the island. Fair to say?
Correct.
And if I understand your complaint, and I don't want to put words in your mouth, you're basically saying that because you don't receive the same services in the county, you should have the development charge waived for this new cabin you're constructing.
Correct.
And would you also agree with me that that argument would apply to anybody else in the same shoes? Anybody else who wants to build on an island who's not going to get services should not have to pay a development charge. You shouldn't get special treatment. You don't think anybody who's not getting services should have to pay a development charge?
I can just speak for myself on this matter here.
Okay. Those are my only questions. Thank you, Mr. Moser.
Thank you.
And Mr. Moser, do you have any other evidence that you wish to put in at this time?
No, I think everything has been said. I'm just questioning that the access to the island is hard, and I think that your fee structure kind of represents that already, that lower usage of services deserve a lower development charge, and I think the island somehow got missed to be differentiated in that way.
Okay, thank you very much. Mr. Tressler, I turn next to you for the county's evidence.
Thank you. I'm wondering if I can have Mr. I'm not sure if we had Mr. Moser sworn or affirmed, or what your procedure is. I guess my question is, do you wish to have Mr. Schertzer sworn or affirmed?
Just give me one quick second, Mr. Tressler. Thank you for your indulgence. We do not need either person to be sworn in.
Okay. So if I could just, Mr. Schertzer, are you live there?
I am.
And I just
Good
wanted to
afternoon,
make
everyone.
sure. Thank you. And I just wanted to make sure that everyone has a copy of the will say statement prepared by Mr. Schertzer.
Yep.
So, Mr. Schertzer, I'm going to ask you to turn to the second page. We don't need to, we've already gone through the agreed upon facts.
Mr. Tressler, I'm just going to interrupt you. I apologize for that for a quick second. I think we're going to enter this will say statement as an exhibit.
Please.
So could we treat that as exhibit number 2?
Thank you.
Go right ahead.
So, Mr. Schertzer, if you don't mind, I'd like to begin with the page entitled Purpose of Development Charges.
Sure, and I'll try and share my screen here. So it's benefit. Let's see if I can do that.
So we can just go through this and
Everyone see that?
you've already answered, you've already answered the question, but I'll ask it anyways. Can you explain to council the purpose of the development charges imposed by the two bylaws that we're considering here today?
Yeah, for sure. And thank you, Chair Hicks and members of the committee, and thanks to Mr. Moser for your presentation earlier. So development charges are essentially used to pay for capital projects that are needed to meet increased demand for services and infrastructure that's generated by growth. So more people in the county means more vehicles on our roads, more demand for things like ambulances and health services, etc. Development charges are fees charged to each new development that help to offset those increased costs and may only be used for the purpose for which they are collected.
And we're going to get into what they're used for later in this?
Correct.
Okay. Then you talk about it in the next page, you talk about a background study. Can you explain to council why was that study undertaken?
Yeah, for sure. Through you, Chair Hicks, the Development Charges Act requires that a development charges background study be prepared in which development charges are determined. And so the background study identifies all the growth related net capital costs that are going to be required in order to accommodate future development that's forecast to happen in Grey County. And then these costs are apportioned to residential and non-residential development in a manner that reflects that increase in need for each service. The latest development charge background study was prepared in 2016, and then a copy of which can be found on the website, and I attached a link to the presentation for everyone's information. So we are actually in the process of currently reviewing our development charges background study and updating our development charge bylaws. But this current background study and then the bylaws that are in place are the ones that are in effect today.
So will there be another background study for the next version of the bylaw?
That's correct. And we're currently in the process, the county is currently in the process of going through that. That process is required under the Act, and there will be updated development charges bylaws as a result of that process. Should council pass those will be then approved and come into effect in 2022.
Now, would Mr. Moser have the right to provide input? And I guess I'm speaking Mr. Moser specifically, but is the public generally afforded an opportunity to provide input in the development of these bylaws?
For sure. We, under the Act, we're required to have a public meeting. We're required to post the draft background study as well as the draft bylaws in advance of the public meeting so that members of the public can review that. We will, of course, post those on our website. We will obviously try to spread the news as much as possible through media channels, hopefully, and be able to identify what's being proposed from a county perspective for the new updated bylaws. But as noted,
and same question with respect to the existing bylaws. Was there a public consultation process before those were brought into force?
That's correct. And that occurred back in 2016. And under the Development Charges Act, municipalities are required to go through that process and review and update their bylaws every 5 years. So that's why we're currently in the 5-year period in 2021 of doing that process.
Okay, if I could get you to turn to the next page so that we can consider the bylaws that have resulted in the charge that Mr. Moser is complaining about.
Yeah, for sure. So the development charge background study served as the basis for the development charge rates approved by County Council on October 4, 2016 through bylaws 4949-16 and 4950-16 as amended. The bylaws came into effect on January 1st, 2017 and remain in force until January 1st of 2022. As discussed, the development charge bylaws do apply to all lands within the County of Grey. This includes White Cloud Island and Griffith Island. They are part of Grey County. And the charges are levied on a uniform basis, applied across the county. And therefore, there are no area rate specific charges in our current, in the county's current development charges bylaws.
Now, I want to ask you about that. Do you know why that decision was made to go with the uniform rate versus an area specific rate?
Yeah, through discussions with the Development Charges Steering Committee at the time and with County Council, their majority of the charge is associated with roads and related works. In fact, just under 93% of the current charge is based on county roads. And the county roads essentially act as a network, county road network that's throughout the county. And based on the fact that 93% of the charge is related to the county roads, council at that time felt it best not to apply an area rate charge and to apply a uniform charge across the county.
Okay. So in the neest page of your presentation, you've pointed out specific sections of the bylaw that I believe you wanted to bring to the attention of council.
Yes, yes, I do. The first is section 3 of both bylaws. And I'll just note that this section 3 notes that this bylaw applies to all lands in the geographic area of the county, whether or not the land is exempt from taxation under the Assessment Act as amended. Section 4 is and Section 5 are under a title called Designation of Services. And Section 4 states that it is hereby declared by council that all development within the area to which this bylaw applies will increase the need for services. And then Section 5 of both bylaws indicates that the development charge applicable to a development as determined under this bylaw shall apply without regard to the services required or used by an individual development.
And I'm just going to stop you there just for the benefit of Mr. Moser and council. I just want to flag this because when I give the submission, this is essentially, we will be taking the position, this is a full answer to Mr. Moser's complaint. But I'll get you to continue. You have reference to some definitions underneath, Mr. Schertzer? I
do. I identified 2 definitions, one being the residential use. And again, going back to the agreed upon facts, the 3-season cabin is a residential use. And residential use defines as lands, buildings, or structures or portions thereof used or designed or intended for use as a home or residence of one or more individuals, and shall include a single attached dwelling, a semi-detached dwelling, row dwelling, multiple dwelling, and apartment dwelling, the residential portion of a mixed-use building or structure of a single detached dwelling.
And I'm going to stop you there. Is there any distinction made between seasonal and permanent residences when determining whether or not something is residential or not?
Not in the current bylaws, no.
Okay.
And then the definition for a single detached dwelling means residential buildings, each of which contain a single dwelling unit that are not attached to other buildings.
All right. And then you, on the next page, I think you've simply shown how the development charge is broken down between various county services.
Yeah, I have. So this actually, I've taken these from our development charges brochure, we call it. That's also posted on our website. It provides some further information and background information about the county development charge, what the current charge rate is, because that does change every year based on a cost of indexing that's conducted every year. And then it also outlines a percent breakdown of charge by designated service. So with respect to this, so this, again, the left side of the slide shows that the 2021 development charge rates based on the different types of developments. These rates are applied to new developments at the time of the building permit application. The development charge rates are calculated by the local municipality at that time of building permit, And then the local municipalities collect the county development charge on behalf of the county, and then they remit the county development charges collected to the county on a monthly basis. This table on the right, it shows the percent of the county development charge by designated service. And as noted previously, you can see that just under 93% of the county's development charge is associated with county roads and related works. And the next two highest include general government. This includes like special studies related to growth and development in order to be able to plan for that growth. And then the next highest is land ambulance, which is just under 2% of the charge. So just between the roads and related works and land ambulance, these services represent 95% of the county's development charges.
So, Mr. Schertzer, I asked these same questions to Mr. Moser, but I'll ask you for the sake of completeness. With respect to the Moser proposed development, would it be your expectation that the normal use of this property would involve utilizing the county road network?
Yes, it would.
And would be your expectation that the normal use, and the reason why I say normal use, you could always conceive of a situation, I suppose, where someone gets to their property by helicopter or has a private doctor or something like that. But would the normal use of this property be expected to utilize emergency services?
It would in the case of an emergency. And as Mr. Moser indicated, I hope that never occurs for him and his family's sake. But yes, in case of an emergency, that would be correct.
Okay. And then on the next page of your presentation, you've gone through the various exemptions from the development charge. I'm not going to ask you to go through those. I'm just going to ask you whether or not you are of the opinion that an exemption applies to Mr. Moser's property.
No, an exemption does not apply in what Mr. Moser is proposing.
And then last of all, in your presentation, you've got a summary page. Can you bring council through that?
For sure. So the development charges applies to all lands within the county and are levied on a uniform basis countywide. And that's based on Section 3 of development charges bylaws, as well as based on the development charges background study that led to the charge that's being calculated. White Cloud Island is part of the county, and this is one of the agreed upon facts. There are no exemptions for residential development on White Cloud Island or for seasonal residential uses in the current county development charge bylaws. The development charge applicable to a development shall apply without regard to the services required or used by an individual development. So even though it's, as Mr. Moser, I think, indicated, is going to be using his cabin only a certain percent of the year, Section 5 indicates that the development charge applies to development regardless of the level of services that are utilized. Notwithstanding Section 5, residents of White Cloud Island under normal circumstances will be utilizing county services such as county roads to access the dock, and potentially ambulance and paramedic services if, like I said, if there was ever a case of emergency, as noted previously. And as noted, these two services alone represent 95% of the designated services associated with the county's development charges. As noted previously, the proposed 3-season cabin is considered a single detached dwelling based on the definitions contained in the county's development charges bylaws. And therefore, a single detached unit development charge would apply to the development being proposed by Mr. Moser, which is currently a total of $7,524 per single detached dwelling.
Okay, three final questions relating to the appeal. In your opinion, has the development charge imposed on Mr. Moser been incorrectly determined?
No, it has been correctly determined, in my opinion.
In your opinion, are there any credits that he's entitled to that he hasn't been provided, credits against the development charge?
No, and through discussions with Mr. Moser previously, he confirmed that there was no previous dwellings on the property, so a credit would not apply in this particular case.
And last of all, Mr. Schertzer, has there been, in your opinion, any error in the application of the development charge bylaws in this case?
No, not in my opinion.
Those are my questions for Mr. Schertzer, subject to anything Mr. Moser arising from what Mr. Moser might ask or anything arising from what council might want to ask.
Very much. Excuse me, Mr. Trestlin. Mr. Moser, it's now your turn if you would like to ask any questions of Mr. Schertzer.
Yeah, I mean, I don't really have a lot of questions here. You're basically outlining the bylaw and what the current state is. Moving forward with the new development charge study, could you imagine that that things like this could be considered? You have right now already a breakdown with apartment buildings and other dwellings, and not everybody pays the same amount based on also certain utilization of the services. Could you see that an island like White Cloud Island could be included as an exception?
Through you, Chair Hicks, I can't speak on behalf of council, but as noted, members of the public would have the opportunity to provide those comments to council as part of the drafting of the new development charge bylaws. That's something that could be considered by council as part of that process. So there, like I said, there will be opportunities to provide those comments to council in the future for their consideration. As noted previously, the council has determined that not applying an area rate charge is most appropriate based on the fact that the majority of the current development charge is based on county roads and related works, which, as I mentioned, operates on a county road, county-wide network.
Maybe one more question. And how much does the county spend for winter maintenance of the roads? I'm asking because I said I'm using it 6% of the time. I will use those roads, but I will use it very lightly. I will also not use them in the winter, where most of the maintenance happens on these roads. How does that look like? How much does the county spend on winter maintenance of these roads?
It's a really good question. I don't have that at my fingertips. I will see if I can find that quickly. If the committee will just bear with me for a second.
I guess if I may interject, Mr. Moser, are you trying to get like the differentiation between maintenance, winter maintenance versus road maintenance?
I just want to point out that I'm not using these roads in the winter, and I would think that winter maintenance is a significant amount of money that you're spending to maintaining these roads.
We don't take any issue with, we'd concede that. That's not contested. I don't know if the council needs the exact percentage, but we're happy to concede that, and we don't take issue with that fact.
Okay.
So, Mr. Trestlin, the county does not take issue with the fact that Mr. Moser is saying he does not use the roadways in the winter months.
Yeah, we don't take issue with that.
Mr. Moser?
That's good.
Are you finished, sir?
Yep.
Okay. Anything else, Mr. Trestlin?
No, that's the evidence on behalf of the county. Thank you.
Okay, thank you very much. So we're going to turn to argumentation now on the bylaws. I'm going to turn to council for a second here. Thank you for your indulgence. I'm being told that we don't necessarily have to put the bylaws in as an exhibit, but it can't hurt. So with that said, I think we will put it in, and perhaps we'll group them all together and put them in as one exhibit. So I'm referencing bylaw 4950-16 and bylaw 4949-16. And then we have the bylaws from the Township of Georgian Bluffs, which are bylaw 2020-024. And I believe that's it. So those three documents. Any objection today to those three documents being treated as Exhibit 3?
Nope.
Okay, then so be it. So, Mr. Moser, we're going to turn first of all to you again. So we're now inviting any submissions that you may want to make with respect to the bylaws that I've just named. Any questions about that?
No, I don't. I would just like to see a more differentiated fee structure.
I'm sorry, I didn't hear you clearly what you just said, sir. Can you please repeat?
I don't. I just what I said is I would just appreciate a more differentiated fee structure for these development charges. And I think the island should be considered moving forward.
And other than that, is there anything else, Mr. Moser, that you want to, any other submissions you want to make with respect to the bylaws?
No.
So we'll turn next to you, Mr. Tresslin.
I'll try to be equally brief, Mr. Chairman. Without any suggestion of being condescending, I sympathize with this gentleman's complaint, but I'm going to be asking council to dismiss the complaint. And the basis for the dismissal, really, Mr. Schertzer's done the work for me, but in it's section 5 of the development charges bylaws. The development charge should be applicable to a development as determined under this bylaw, and it's to apply without regard to the services required or used by an individual development. I understand that Mr. Moser doesn't like that. I understand he thinks it's unfair, and he can make that pitch to council with respect to the new bylaw, but this bylaw applies to everybody. And he was careful, and he was very fair in his answer to my cross-examination. Are you suggesting everybody on the island should get a break? And he said, well, I'm just here to speak on behalf of myself. And I think that was an honest and smart answer, but council needs to make a decision. The decision was made when the development charges bylaws were brought into force to make a uniform rate in recognition that the vast majority relates to the roads and the emergency services, which are applicable to any development. Obviously, we hope no one has to have an emergency, but the emergency services are there for all if required, and the roads are there for all to use, even if you have the private helicopter, because someone could come to this committee. Mr. Moser doesn't, but someone could come to this make a complaint and say, listen, I don't need the roads. I got my private helicopter. And your development charge bylaw, as it's presently structured, is without regard for someone's use of the services. So I'm going to ask, with all due respect to Mr. Moser, who has prepared a very professional presentation, and he's acquitted himself well, but I'm going to ask the council to dismiss the complaint on the basis that you cannot and really don't have the jurisdiction to give him the relief that he's seeking, which is a waiver of a development charge, which Mr. Schertzer has told you has been properly applied to this property. And again, I'd come back to section 20 of the act, which states the basis on which a person can make a complaint. They can complain if the development charge was incorrectly determined. There's no suggestion of that. They can obviously make a complaint if there's a credit available to them that hasn't been provided to them. Or they can make a complaint, and Mr. Chairman, you identified this as really the only one I think Mr. Moser could possibly hang his hat on. They could make a complaint if there was an error in the application of the development charge bylaw. And basically what Mr. Moser is alleging today is not that there's been an error in the application of the bylaw. He's basically saying there's been unfairness or an error in the creation of the bylaw. And that's not a basis on which a complaint should be upheld. But again, I have nothing but respect for him. He's not happy about having to pay a hefty price for developing his cabin. But I don't see that the county can give him any relief, and I ask that the complaint be dismissed.
Just one quick second, I'm making some notes. Okay, thank you very much, sir. I believe that concludes all of the submissions. And at this point, the committee will take an opportunity to meet. We will come back to this platform. I'm guessing maybe 20 minutes to half an hour. So if you would stay tuned, we are going to go into another meeting platform and have our own meeting, and then we will come back to this platform and we'll reconvene at that time. Any questions about that?
Nope, thank you.
Mr. Moser, you're
I don't
clear?
think so. Just staying in this call here and wait for you, I guess. Yeah.
Yeah.
Yeah. Thank you.
Okay. So we'll adjourn for 20 minutes to half an hour.
So Olivia, can you put up the "we'll be right back"? And I'll just ask
Yes.
Mr. Moser, Mr. Tresslin to turn your cameras and microphones off. Mr. Moser, Mr. Tresslin, are you available if we reconvene?
Yep. I'm here.
Yes, here, present.
Thank you. Thank you. The committee members will be joining us very shortly then.
Okay, so it looks like we're back. Can everyone hear me?
Yes.
Olivia, are we good to go?
Yes,
Thank you. So the committee has met, and I can communicate that we have made a determination. The decision is to dismiss the complaint, and we will be providing written reasons in accordance with the timelines prescribed. So that's it. Are there any questions from anyone?
No.
Okay. I guess that concludes our meeting for today. I want to thank everyone for the decorum that you showed throughout the process, for the cooperation that we've received. This is a first for the county. So thank you to everyone, and I wish you the best with the rest of your day.
Thank you, sir.
Thank you.
All right.